5 seconds to go. Start. We have here the learned counsel on both sides. This appeal by special leave is directed against the final judgment and order dated 17th May 2022 in CRR number 2615 of 2017 passed by the Calcutta High Court at Calcutta. The appellants herein approach the High Court under Section 482 of the Code of Criminal Procedure 1973 CRPC, seeking quashment of FIR number 189 of 2017, dated 11th April 2017, registered against them and two others at Madhyagram Police Station under Sections 323, 384, 406, 423, 467, 468, 420 and 120B of Indian Penal Code IPC, raising various grounds. The High Court declined to exercise the jurisdiction under Section 482 CRPC, holding that perusal of the case diary as also the materials appearing therefrom prima facie made out a case for investigation. In that view of the matter, the interim order granting stay of all further proceedings pursuant to the registration of the stated FIR was vacated and the stated petition was dismissed. It is to be noted that the aforesaid crime was registered pursuant to the forwarding of an application filed by the respondent herein under section 156(3) CRPC, raising the allegation against the persons named therein, including the appellants, by the learned magistrate for investigation, and thereupon investigation was commenced. The appellants herein assailed the very order for forwarding of the application for investigation under section 156(3) CRPC, the consequential registration of the said FIR, and also the ongoing investigation pursuant thereto, raising various contentions that the application moved by the respondent herein before the learned magistrate did not disclose commission of any cognizable offence, that the allegations in the complaint are actuated by malafidis, that the allegations would reveal that they pertain to pure civil dispute between the parties, and in fact the respondent did resort to civil remedies, that he failed in obtaining favourable order in interlocutory applications moved in a duly instituted suit, and upon its frustration and as a tool for oppression and harassment, he moved the application which culminated in the registration of the FIR without disclosing the crucial aspects, that in respect to the subject matter the suit instituted by him, viz. Title Suit number 363 of 2015, carrying the prayers for a declaration that he is the secretary of the scheduled secule, and also for a permanent injunction restraining defendant numbers 1 and 2 therein, viz. The appellants herein and their men, agents and associates from procuring and or creating any document illegally and or from obstructing him in representing as the secretary of the managing committee, is pending before the first court civil judge junior division at Barasat. It is also contended therein that the respondent herein had suppressed certain further aspects which, that much before the filing of the application based on which the FIR was registered, he was removed from the post of secretary and in fact from the membership of the very board of trustees. Initially, he moved the office of Labour Commissioner, raising grievances against such removal from the office of the secretary before instituting the stated suit. The impugned order would reveal that upon forming the opinion on perusal that they would prima facie make out a case for investigation, the High Court declined to exercise the jurisdiction under section 482 CRPC. It would also reveal that the crucial and relevant contentions raised by the appellants were not at all considered by the High Court. Hence, necessarily, the question to be decided is whether the High Court was justified in declining to invoke the power under section 482 CRPC to quash the order dated 5th April 2017 for forwarding the application filed by the respondent herein carrying allegations qua the appellant for investigation under section 156(3) CRPC, the consequential registration of the FIR and the investigation pursuant thereto qua the appellant in the facts and circumstances of the case, and in view of the settled position in the matter of exercise of inherent powers under section 482 CRPC. There can be no doubt with respect to the position that jurisdiction under section 482 CRPC is to be exercised with care and caution and sparingly. To wit, exercise of the said power must be for securing the ends of justice, and only in cases where refusal to exercise that power may result in the abuse of process of law. Before referring to the relevant authorities on the scope of exercise of power under section 482, it is only apposite to refer to application filed by the respondent herein before the learned additional Chief Judicial Magistrate at Barasat, which was numbered as civil case number 538 of 2017 against Sri Shankar Biswas, Sri Debasis Roy, and the appellants herein seeking for a direction to conduct investigation under section 156(3) CRPC. Stop.